Okay. We are live.
Good afternoon. Welcome to Garfunkel Wild's How to Protect Your Assets and Family Using Trusts. I'm Doris Martin. I'm the head of our estate and trust planning group, and I'm joined by our senior associate, Kristen Walsh. We both work extensively and only in this area. And this seminar is designed to give you an overview of the way in which trusts can work for your family and yourself. It is going to touch on many different concepts, and we are happy afterward to address some of your questions. We have a large number of participants, and if we don't get to the one that you posed, either before or during after this presentation, we are happy to reach out to you to resolve them. We're just going to wait a few more seconds to let everybody log on, and then we'll get started. Once again, in this seminar, we're going to try to give you an overview, explain what trusts are, how they can work in different situations, the different ways they can be used for asset protection, for estate planning, for Medicaid planning, to protect your children, to save taxes. It's a very broad, high-level overview, and there are many of these topics that could be hour or more long presentations in and of themselves. So we hope that this whets your appetite to discuss about these things, and we're happy to discuss with you either in the questions that follow or afterwards your own particular situation and how these things can work for you, or to address questions you might be having about ones that you already have in existence. So I'm going to turn it over to Kristen now to get started, and we will be going over many topics, and we hope that you find this educational and beneficial for your own situation.
Thank you, Dee Dee, and thank you everyone for joining. So we'll start with the real basics. What is a trust? Trust is essentially, it's a written agreement between you and your trustee, who's the person you've chosen to manage the trust assets. And in that agreement, the trustee is agreeing to hold your assets according to certain terms that are defined under your trust agreement. A trust is essentially a legal entity that owns property for a specific purpose. So parts of a trust include the grantor, that's you, that's the person who created the trust. A trustee, that's the person who manages the trust and follows the trust terms. The beneficiary, who can be a person or an entity, and that's the person or entity for whose benefit the trust is held. You also need the property that's going to fund the trust, and you need that written agreement. So as you might know, a trust can be either revocable or irrevocable, and those different types of trusts can have different purposes and different benefits that we will talk about today. So the four main ways we're going to discuss about how trusts can protect your assets and your family. First, we'll talk about how trusts can help simplify the administration of your estate when you pass away and help you to avoid probate, and we'll explain what that means. Next, we'll talk about how trusts can protect assets from estate and gift tax. We'll also talk about how trusts can protect assets from creditors, lawsuits, or even future divorce. And then finally, we'll talk about how trusts can protect assets from the costs of long-term care in the future. So the first way that trusts can protect assets is by helping you to avoid the probate process and simplifying the administration of your estate when you pass away. So probate is the process in which your named executor brings your last will and testament to court and asks the court to validate your will and formally appoint your executor as the person authorized to administer your estate. When you create a will and you name an executor in your will, when you pass away, that executor can't just take that will to the bank and collect your assets, and your executor can't take the will to a real estate closing to sell your house. Instead, the executor first has to have that will validated by a surrogate's court or probate court, depending on the state where you live. And once that process is complete, only then, when the court approves your will and says, yes, this is the last will and testament of the decedent, will the executor have the authority to collect your assets and distribute them to your beneficiaries. So for example, if you die owning a bank account in your individual name and you haven't named a beneficiary, there's no joint owner on the account. When you pass away, no one is going to be able to access that account or collect that account or pass it on to your spouse or your children or whatever it is that you've intended. So you would need that executor appointed by a court in order to collect the assets. And the same thing for maybe your residence. If it's in your name alone and you don't have a joint owner on it, when you pass away, no one's going to be able to sell the residence until there's a court appointed executor. If you don't have a will at all, then the process is not called probate, it's called administration, but the process is quite similar in that the person who's your administrator would go to court and ask for court permission to become your administrator. So the steps of a probate process are as follows. The first step is that the executor is going to likely see an estate attorney to prepare a probate petition. And that's the application that he'll make to the court in order to be appointed. The probate petition will need to be filed with the surrogates court or the probate court, along with your original will. There also need to be, different people need to be notified of the probate proceeding. So depending on your family composition, there's going to be consents that are needed from different family members who may have an interest in your estate. Those are called the interested parties. And they will either need to consent to the probate by signing a waiver and consent form, or if they don't consent, then they will be given an opportunity to appear in court and may need to be served with a citation, which is like a summons, and given a court date to appear in court. And at that time, if they don't appear, then there are no objections and your will can be admitted to probate. But if they do appear, they will have an opportunity to raise questions or objections to your will. Another thing about the probate process is that if your family tree is complicated, or if there are any issues with your will, perhaps your will is very old and you haven't looked at it in a long time, then maybe there will be additional evidence that's required for probate, different affidavits from third parties to explain the family tree, or maybe you can't find the original will that can create an issue. So there are different issues that can come up in the probate proceeding that can make it a bit more complicated. So at the end of the day, if the court is satisfied that the will is your last will and testament, then your will be admitted to probate and your executor will be appointed. So you might have a sense of why you might want to avoid this probate process. But first of all, your will and certain information about your estate will become public record. The probate petition is a public record. Your will become public record that's accessible by anyone, including your creditors. And creditors are known to review the surrogates court or probate court records periodically in order to check and see if an estate has been opened and if there's an executor that they can pursue for payment. So it does have that public aspect to it. In addition, the interested parties that I mentioned before, if their consent is needed or if they are receiving notice of the probate proceeding, that may include an estranged spouse and a child you don't speak with anymore, an estranged sibling, or some other unhappy family member who might not agree that this will is your last will and testament or is not happy with its terms. And now they've received essentially an invitation in the mail to come and or serve personally with an invitation to come and contest your will. Your estate assets cover your executor's costs in defending your will, and an estate litigation can be extremely expensive. So that's definitely something that if you have a complicated family tree, or that there might be issues with family members after you pass away, the probate process is definitely something you'll want to try to avoid. So even in a straightforward probate process, it can take several months, depending on where you live, or if it's contested, it could take years. And in the meantime, your family still will not be able to collect your assets. They won't be able to sell your residence, and they will need to continue to pay the ongoing property taxes, carrying costs, etc., for your residence while they wait for probate to be completed. And of course, all of your assets will be subject to market fluctuations during this process, which could be a problem.
One thing that we encountered over the COVID shutdown was that the surrogates courts in New York, which previously would act fairly quickly, and by quickly I mean within 2 or 3 months, to admit a will to probate, they were not deemed to be what's called essential. And as a result, unless you had a true emergency, and someone passing away and needing to sell a house or collect an account was not deemed an emergency, there was a huge backlog, some of the courts of which are still recovering from. And we always prided ourselves in New York on having a fairly easy to administer probate process. Revocable trusts were not playing a big role until the last 10 years in New York because of that. Places like Florida have more complicated probates. California has more complicated and expensive probates, and those residents in those states for quite a long time used revocable trusts to avoid their state court system. In New York, we didn't have problems with it, but over the past 10 years, as people have experienced, court personnel have retired, replaced by newer people, the delay of COVID, the move to electronic filing, it's really done a number on us. And I would say for the past 10 or so years, we have been exclusively doing revocable trusts instead of wills in an effort to avoid having to go to court and spend the time and delay. In a simple probate, it can cost thousands of dollars plus the court filing fee. And in a complicated one, where you're dealing with people who may not cooperate, it can cost multiples of that. And essentially in a probate process, you are giving people who may not be beneficiaries even basically an invitation to look into all this. And it's really unnecessary. So we now, as a matter of course, strenuously encourage our clients to use revocable trusts, whether they are funded or not during their lifetime, whether they have a complicated family situation or not. It's also particularly important when you don't have close living relatives. You don't have a spouse, you don't have children, may not even have siblings or nieces or nephews, and you may not be close to those people, to have a revocable trust, because if it goes far enough down the family tree in terms of who your close living relatives are, the court will actually appoint a guardian for those people, and the public administrator, which is a lawyer appointed by the county, is appointed to make sure that those people's interests are represented, even if they are not beneficiaries. So we, as a matter of course here, really prefer to only do revocable trusts for people, no matter the dollars or family situation involved.
It can certainly get complicated. And as Dee Dee just said, trusts can help to avoid this process. There are certain exceptions, maybe an asset that you forgot to transfer to your trust, or if you get a large income tax refund or estate tax refund after you pass away, that now you need someone to be able to deposit that check in an estate account. But other than that, if your trust is properly funded, you can have a successor trustee named in the document who is going to be able to step in right away after you pass away, as soon as they have a death certificate in hand, and now can manage, distribute, sell that asset. And we're not going to have that need for court intervention as we would if you didn't have a trust. So beneficiary designations and joint assets are also instrumental in avoiding probate, and they can work together with your trust to help you avoid the probate process. So the way it works is that the revocable trust would own your property during your lifetime. You can transfer your house to your revocable trust or other assets to your revocable trust if your goal is to avoid probate. And you can also serve as the trustee of your revocable trust. So you will still have access and control over those assets just as if they're still yours, and you can change or revoke your trust as you wish during your lifetime. And a revocable trust is used just like a will in that it directs how property passes at your death. So you can say in your revocable trust, maybe you want everything to pass to your spouse, maybe you want everything to pass to your children in equal shares, or some charity or another beneficiary. You could direct that in your revocable trust. And again, you can change that over time if you decide to do so. And then also the revocable trust, it does reduce the chance of disputes and litigation after you pass away, because people are not getting that notice in the mail and essentially an invitation to fight the will. The trustee is able to handle matters independently by just following the terms of the trust. Another thing is that if you decide to have your beneficiaries inherit in a continuing trust, and there might be different reasons that you would want that, which we'll also address in this presentation, a revocable trust avoids the need for court supervision over continuing trusts for your beneficiaries. So if there are trusts that are lasting after you pass away, your trustee is not going to need to go back and forth to court to get approval. Whereas if you included a trust under your will, that trustee would need to go and get formally appointed by the court and would need to go to court for different decisions, maybe to file accountings. So the revocable trust can help avoid that issue that comes up with testamentary trusts.
And one thing that continually comes up about trusts created under wills is when a trustee changes, and perhaps the trustee has passed away, perhaps they've come to an agreement with the family that they will step down in place of someone who is more in tune with the family's thinking. And that process has become one that costs thousands of dollars, and the court takes, we have one now that we're waiting almost a year for the court even to acknowledge that they have reviewed the file. And in the meantime, this trust has no one who's able to manage anything, no one who's able to change the investments, no one who's able to sign documents when it owns an interest in various businesses. And it's that delay and expense that if you have a revocable trust, it's a piece of paper that someone signs resigning and someone else steps in. It does not involve having to spend thousands of dollars in legal fees, and more importantly, the delay. So it's really important. So I think you should look at a trust. It's your will. It's how everything's disposed of. It's in place of your will. It's revocable. It has no income tax consequences to creating it. There's no realization of gain. It does not even file a separate tax return. Everything on it gets reported on your tax return. There's very, very, very minimal costs involved to running it after it is initially set up. And it is as changeable as your will. And you should look at it as sort of a will substitute.
Yeah, and while some of the other ways that trust can provide protection, they may not apply to everyone listening. The revocable trust, for the most part, will apply to, if not all of you, 99% of you, because it just acts instead of a will, and it allows you full control over your lifetime. There's not much of a downside to using one.
Other than paying the lawyers to set it up and making sure all your assets get included in it.
And if you were setting up a will, you'd have the same problem. Okay, so the next way that we'll talk about the trust can protect assets is by sheltering assets from estate and gift tax. So just to give you the basics of estate and gift tax, estate tax is a tax on the transfer of property when you pass away, and gift tax is a tax on the transfer of property during your lifetime, and that's if the transfer is made and you receive nothing in return, or if you receive not full value in return, that would be considered a gift. That could be subject to gift tax. So when you're transferring assets between spouses, either during lifetime or at death, those assets can pass to your spouse free of any gift or estate tax. That's called the unlimited marital deduction. But assets passing to others are subject to gift or estate tax once you exceed the federal lifetime exemption. And currently for 2023, that's $12.92 million. And that amount is set to be reduced by approximately half in 2026, and we anticipate that those changes will take place, and we plan for those changes to take place, but you never know if the laws can change depending on the new administration coming in, if the new administration comes in. And the federal estate tax rate on amounts in excess of the exemption amount is 40%. So assets in excess of 12.92 million, if you died in 2023, they would be taxed at a rate of 40%. In addition, your state may also have an estate tax. New York and Connecticut do, Florida and New Jersey do not. And New Jersey has an inheritance tax that applies only to certain beneficiaries. And here in New York, if your estate exceeds New York's estate tax exemption, which is currently $6.58 million, even by a small amount, there is no exemption at all, and the entire estate, not just the excess, is taxed. And New York's top estate tax rate is 16%. So if you have a taxable estate, you could be looking at significant estate tax. And so for that reason, many clients look to see what they can do to save on estate tax when they pass away.
And one important point to know about Connecticut and New York is that while they have their own exemptions, if the first estate, if your estate, let's say you're a married couple and the first spouse to die's estate does not take advantage of it by setting up a trust for the surviving spouse or other family members, that exemption is lost and is not transferred to the spouse. It's not what we call portable. The IRS exemption, the almost 13 million, is transferable to the surviving spouse to use on their own estate. And as far as the law currently provides, will not be revoked if you were to pass away before 2026. The spouse would be entitled to keep that larger exemption from you. But in New York and Connecticut, you do have to form a trust or use it up in another way so that that amount is set aside from your spouse's taxable estate. And because those New York and Connecticut do not allow the spouse to inherit your unused exemption. So that is something that I would also say is in 90% of the revocable trusts or wills, that we do allow the spouse to decide how much to fund that trust with, whether it makes sense, because we don't have a crystal ball. We don't know if there will be an estate tax when you pass away. We don't know where the assets will be. We don't know what state you'll be living in. So most of the time, everything is given to the spouse with the option of creating a trust with the state exemption amount at their first spouse's death, so that it doesn't evaporate into the ether and the surviving spouse's estate remains within the state exemption. And by the way, Florida has no estate tax, as Kristen mentioned, and if many people do end up moving down there for tax reasons, sometimes they come back and they still have to confront this issue. So this is something that has to be taken into consideration over the rest of your life, where you're living and what the ramifications are.
Okay, so you can use irrevocable trust for sheltering assets from gift and estate tax. And so the trust does have to be irrevocable in order to get protection for this reason. And when you transfer assets to an irrevocable trust, as long as the irrevocable trust has acceptable terms to the IRS, you can remove assets and their future appreciation from your taxable estate. When you set up an irrevocable trust for estate tax purposes, you cannot be a beneficiary, you cannot be a trustee. The transfer has to be irrevocable, and you are giving up control and enjoyment of assets. However, your spouse and children, or whoever you choose to be beneficiaries, can enjoy the trust assets. So we'll talk about just a few different types of irrevocable trusts that are used for estate tax planning. And the first one is very useful and popular. It is an irrevocable life insurance trust. And this is because life insurance proceeds are not exempt from estate tax, but many people carry life insurance policies with big death benefits. It could be $1 million or a few $1 million or more. And you want to make sure that those millions of dollars are kept outside of your taxable estate and are not going to be taxed at a rate of 40% or more when you pass away.
This is a very common misconception, because life insurance proceeds are not subject to income tax in the hands of the recipient. And if your wife was the beneficiary or your husband, they are not subject to estate tax because of the free marital deduction between spouses. But if those proceeds are added into your spouse's hands, and then your spouse has their own assets, which they've inherited from you also, if the spouse is then going to be over the exemption at the time of their death, a life insurance trust is a way to keep that out of the equation.
Right. And you have to transfer ownership of the life insurance policy to the trust, and the trust will also be the beneficiary of the policy. And then you'll have to live 3 years from the date of the gift in order to qualify the trust for the estate tax exemption. And at that point, when you pass away, premium, the life insurance death benefit will be kept separate from your taxable estate. And it's not giving up all that much while you're living, unless the policy has significant cash value that you were looking to use. Then giving away a life insurance policy to a trust, as I said, if there's not a lot of cash value there that you needed to depend on, can be somewhat pain-free because you weren't planning on accessing that life insurance policy anyway while you were alive. and your beneficiaries will still have access to all the death benefit proceeds when you pass away. So the premium payments, the way that it's done when you transfer ownership of the life insurance policy to the trust, you still have to make the premium payment somehow. So you'll be contributing the premium payment amounts to the trust on an ongoing basis so that the trust can then pay the premiums. And those are taxable gifts, but as long as those premium payments are under $17,000 per beneficiary or $34,000 for a married couple each year, then you won't have to report those premium payments on a gift tax return, and you won't have to pay any gift tax.
Now, life insurance trusts do have more administration that goes on than some certain other trusts. In order to get the annual tax-free exclusion for premium payments, you actually have to send a notice to the beneficiaries telling them that you paid this premium amount and it is considered a gift to them. And here's the catch, that they have 30 days from the date you send the notice to them to ask that that money be given to them. Now, if anybody ever did that the next year, you wouldn't pay those premiums and you tell them that. But it does come with an annual reporting that has to be complied with. You don't legally have to have a separate account to pay the premiums through. You can pay the premiums directly, and that's acceptable, but you do have to send that notice. And we do, when we set these up, we give you a model notice, we involve your accountant, but we rely on you to make sure that those notices are sent. You can also rely on your trustee, but generally you've asked other family members to serve and you're trying to make their lives easier. So you would be involved in making sure that that happens. So there is a certain degree of administration that goes along with the life insurance trust, in addition to making sure that the owner and beneficiary are changed to the trust, which often though we recommend that and work with people's advisors to make sure. There are instances where clients for various reasons don't carry that out, and it turns out they've never funded their insurance trust. And so there are some initial things that have to be done, and there is ongoing administration with respect to life insurance trust. They do file a tax return if there is taxable income. For example, if you actually had an account that earned interest, but again, it's filed generally on your tax return, because you remain the owner for income tax purposes only on any interest or dividends that are generated. And if you do have a policy that has a large amount of cash value because it was pitched to you as a tax-free savings device, one that you could get loans from in the future, that may not be one that you want to contribute to a life insurance trust, because otherwise you're relying on your spouse or children to get you access to being beneficiaries to that cash value. So it all has to be considered and decided whether that's an appropriate policy to put in the trust. And often people have term insurance that by the time their death occurs is long gone. So life insurance trusts are often set up and they're designed to exist while your insurance exists, but over time, insurance gets expensive. People decide to drop it when they no longer have mortgages and children in school and want to provide a cushion for a younger spouse to have if there is an early death. So these insurance trusts often will disappear of their own accord over someone's life. It's actually pretty rare that you have someone who's lived a full life ending up with insurance still in place.
Okay. And then the next irrevocable trust that we'll talk about that can help save on estate tax is the Spousal Lifetime Access Trust, also called a SLAT. So these trusts became very popular, I would say, in the past few years, as we've had this very high exemption that's creeping up along with inflation each year. And there's been this threat that the exemption is going to be reduced. So what clients would like to do and take advantage of this high exemption while it's here before it's reduced by giving away a very large amount up to the exemption amount, 12.92 million, without having to pay any gift tax while they can. And so creating a spousal lifetime access trust it's an irrevocable trust for the benefit of your spouse. And you can also include your children as beneficiaries if you like. And your spouse can be a trustee and can access or use the funds in the SLAT if that's desirable. And so basically you're giving this large amount away to this trust, but your spouse will still have access and be able to enjoy the trust fund. So that's very appealing to clients. And so even though you cannot access the trust funds directly, you can enjoy the trust funds indirectly through your spouse. There's an issue, of course, if your spouse passes away before you. So that's important to consider when you're setting up slats, which one is more likely to outlive the other. And of course, if you get divorced, that could result in you losing this indirect access to the trust. It may be possible to take loans from the trust, but that's definitely something to consider if you're thinking of setting up a slat.
And it only makes sense to do a slat if you're doing it to take advantage of the exemption. If you were going to give more than we think the exemption is going to be in 2026. So for example, if the exemption falls to about 7 in 2026, you will have to have given 8, 9, 10, 11, 12, 13 million to this trust in order to take advantage of the part of the exemption that may be revoked. So this is really only designed for people who have 30, 40, $50 million, and you have to be willing to take the risk that you won't have access to these funds in the future. So it's not designed for people who are under that exemption or who don't feel comfortable having perhaps loss of access on their spouse's death. It's really only for the people who are in the top percentage of wealth in this country.
Right. And if you pay the income taxes on the trust assets, that would be called the grantor trust, and the trust has to be designed that way and include certain strings that make it a grantor trust. Then the trust can grow even more because it will grow, free of having to pay income tax, and you can get more assets out of your taxable estate by paying those income taxes.
And that grantor trust concept is also another very powerful planning technique that applies to all irrevocable trusts, where if you agree to pay the income taxes, to continue to pay the income taxes on property that was once yours, but you continue to pay them after they've been given away, that allows the trust to grow because it's not getting depleted and is not, surprisingly, considered a gift that you're making. So if you're already maxing out on your giving and giving the $17,000 a year, this allows you to give even more because you're essentially paying the beneficiary's tax liability instead of having the trust pay it. So that is also a very standard and technique that is used on most irrevocable trusts during your life. You can always turn off that spigot and say, I don't want to pay anymore, but you can't turn it on and off, depending on how flush you feel that year or not.
So you can see how setting up a slat or another type of irrevocable trust can help you save a lot on estate taxes. And then this trust, the annual exclusion trust, this is also a very powerful tool that many clients can take advantage of. And that's a trust where you can give up to $17,000 per year to as many beneficiaries as the trust has. That's the annual gift tax exclusion that you'd be taking advantage of by doing so. And the annual exclusion gifts don't use up your lifetime exemption. They're kind of a freebie. So you can set up this annual exclusion trust for the benefit of maybe all your children, your grandchildren, and then as many beneficiaries as you have, you can take your available annual gift tax exclusion and multiply it by the number of beneficiaries, and that's how much you can give to the trust gift tax free every year. So you can imagine how that can add up over the years and really result in estate tax savings at the end of the day.
And these annual gifts that you can make, they don't have to be in a trust. If you feel comfortable with the beneficiary receiving that amount and they may actually need it for where they are in life, you can make direct gifts to people. We don't recommend doing it for minors or people who aren't yet quite settled in their life. And that's where, or if your children don't need the money, but you still want to reduce your own estate, then we use trusts. And I would have to say that after setting up a revocable trust and a life insurance trust, that an annual exclusion trust and annual exclusion gifts are the most powerful things that you can do, because if you start fairly young, you can give a tremendous amount of money away, and you can also build that up out of your estate. And that, before we even get to slats and other more complicated things, this is one of the most basic planning tools that people do use as part of their planning. There's other, as I mentioned, more complicated things. There's something called a qualified personal residence trust, sometimes referred to as a QPRIT, that you can put your home in and you can continue to live there, paying the expenses. But once a term that you believe you will survive depending on your age, 10, 15, 20, 30 years, you have to start paying rent, which with the explosion in the value of homes, and certainly vacation homes in certain places, this may become onerous, but you then would be stuck with paying that rent if you wanted to keep it out of your estate. But again, if you have enough assets, you can look at the rent as something you want to pay a lot of, because it is another way that is not considered a taxable gift to your children. So if you own a home in a vacation area and that rental could be tens of thousands of dollars, that's another number that can go to your family without paying estate tax. Another popular device is called a grantor retained annuity trust, or a GRAT, where you put in assets that you think will appreciate more than the IRS thinks assets appreciate. There is a rate set. And if you do better than the IRS rate, that appreciation will remain in your children or other beneficiaries' hands. You will essentially get back what you put into it. And this is complicated in that you do it for 2 or 3 years. It's successful, you do another one, and you keep doing another one. The IRS hates these kind of trusts, and they're trying to get rid of them continually, but they've never been able to successfully eliminate them. But that is another device that allows a lot of families to transfer wealth. Again, because you're just giving up the appreciation. Intentionally defective grantor trusts are the grantor trust concept we spoke about before. Any irrevocable trust can be intentionally defective. Some people call these idiots. And that just means you're paying the income tax on them and letting the trust grow more that way. There's also charitable trusts. If you want a portion of your estate to go to charity, which then reduces the taxable portion for your family, a charity would either get something up front or at the end of the day, and your other beneficiaries the rest. And as part of a basic planning technique, which we talked about before, the credit shelter trust, where in states like New York or Connecticut, you need to set up a trust in your state exemption amount of the first death, or your spouse, if their own assets exceed the exemption of their death, would pay tax on, and it's another way to reduce the spouse's estate. Another popular idea that we hear from many clients, particularly those in high-risk professions like physicians or real estate owners, is how can I protect my assets from creditors? Unfortunately, you can't have your cake and eat it too, and New York in particular does not let you set up a trust for your own benefit and be protected, whether it's revocable or irrevocable, but you can set up trusts for your family's benefit. If you do want access to that trust, either by controlling who the trustee is, or controlling who the investments are done by, or even doing the investments yourself, or having the ability to take a loan from it, the more control and benefits you have the potential to receive, the more vulnerable it is. You can also form these trusts, or have to form these trusts, if they have access for you or rights for you in other states such as Delaware, Nevada, Alaska, or even offshore. In order to get the benefits of those states' laws and have the kind of access that you potentially might want, you have to select a trustee in that other jurisdiction. Those jurisdictions make it very hard for creditors. The creditor has to hire a lawyer. They have a shortened amount of time to pursue it, but you have to pay that trustee several $1,000s a year. It's either a professional trust company or a lawyer in that state, and they will either want to have control of the assets, or you can have outside managers and continue the way your assets are invested, but there is a cost to doing it. So it doesn't make sense to do unless we're talking about, at least $1 million being put aside. And so you have to first be willing not to have access to the funds yourself if you want the most protection you can get. And if you do want access, then you do need to use these other states' laws. You also have to do it before you have claims that are asserted against you. You cannot render yourself insolvent by doing this. There's, financial disclosures that have to go on before a lawyer would agree to do this kind of trust for you. And again, with any kind of asset protection devices, there's no absolute magic silver bullet, but these are devices that you can use to make it harder for a creditor and perhaps settle early. Typically we see any kind of malpractice judgments being settled for the amount of the insurance. There have been historically some cases that went outside of that, but in general, that's covered by that. But this is for, if this is necessary for you to sleep at night and have the most protection possible, there are other things you can do. And there are many other things to do, from an asset protection device. In terms of your retirement accounts are protected, and you can in fact transfer them. Cash value in a life insurance in some state is protected. You could form an LLC and give pieces of it away and remain the investment manager. And that would make it harder for a creditor to reach or certainly encourage a settlement. So there are other ways to do it. To protect the assets, again, as we mentioned before, it has to be irrevocable. You need to have someone other than you as the independent trustee making distributions if you're a possible recipient or your family is. And again, that involves finding someone, and if they have to be paid, they have to be paid. You can't be a trustee. You can use other states' laws. And you have to do this early on when there's no risk that you already have an existing creditor. I think we discussed this already, so we'll skip this slide.
Okay.
And now we're going to talk about trust and divorce. So again, those asset protection trusts, if they're for your benefit to protect you from a spouse, have to be done in other jurisdictions, and certain jurisdictions let spouse still have access and certain jurisdictions do not. So you have to consider that. If you're the beneficiary of a trust, and another way to protect yourself is to ask if you expect to inherit money from your parents, that they do not leave assets to you outright, that they put them in a trust for your benefit, and they select someone to be the trustee that can be the gatekeeper, so that you can say if someone sues you that you have no rights to that, you depend on an independent trustee to receive any distributions. You can also create these trusts for your children if you want to protect them, whether they have, marriages that you have questions about, or, no one knows. Sometimes marriages happen 20 or 30 years after people have a fine situation. So it's just another way that your children can be protected and they don't just take inheritances from you and put them in a joint account, which destroys any protection they had under the law. Divorces are often based on equitable reasoning, and if you have a trust that you have lived on during your marriage and taken regular distributions on, an aggressive matrimonial lawyer could say this is also available in the event of a divorce. Or if your child is the sole beneficiary and can take money out for themselves, an aggressive divorce lawyer could say you have to take money out to support your family. So there are jurisdictions, that make differences, but you can try to protect yourself by going into other states, or you can try to protect your children so that the money that you've bequeathed to them remains for their children's benefit and not their estranged spouse's new family.
I think having that independent trustee who has full discretion over trust distributions is really key for asset protection, both from creditors and for divorce purposes as well.
And we've touched on some of these concepts here about malpractice insurance and retirement savings. And make sure if you have the ability to inherit from someone else, you tell them don't leave it to me outright. And even if it's your parents and they don't have any other reason to set up a more complicated plan to achieve that, you could tell them that you'll pay for it. That's in your interest, that a more sophisticated plan be put in place. And then there's always, we get constant calls when someone's child is getting married. Should they do a prenup? If you wait too long, there's issues about whether it's enforceable. You're the bad guy. Everyone hates you. No one ever really wants to do it. Prenuptial agreements can cost easily $10,000. They can't be done on the eve of the marriage. Sometimes your children don't really have a lot of money at the time, and it seems like overkill. So if you integrate those concepts into your planning for your children, then the pre and post nuptial agreements don't mean so much. But they are something that, of course, would protect your child more than anything else. But there's just a lot of resistance when people get into the nitty-gritty and the emotions around a marriage, that these things actually come to pass. But trust is a way to do an end run around that. And then your children can, when they inherit, just blame you that this was set up this way, and I'm sorry I can't invest in your wacky business idea that might not come to pass.
Okay, the next topic and way that trust can help you to protect assets is by protecting assets from the cost of long-term care. So we're talking about long-term care, we're talking about home care and nursing home care later in life. And for many people, how that would be paid for is a big concern. Unless you have a long-term care insurance policy, other insurance is not going to pay for home care services or nursing home care services. So because long-term care can be so very expensive and insurance doesn't cover it, many people do engage in Medicaid planning in order to impoverish themselves enough to qualify for Medicaid, because Medicaid is the only government health insurance program that will cover the cost of home care or nursing home care. Medicare does not cover those long-term care services. So Medicaid is a needs-based program, and you have to have only nominal resources in your name in order to qualify. So you would really, if you were to engage in Medicaid planning, you really have to impoverish yourself, and also consider that if you have a high income coming in from retirement accounts or anything like that, then that income is also going to be subject to paying your long-term care costs as well. Many states have a 5-year look-back period. You might have heard of the 5-year look-back. And that just means that if you're applying for Medicaid for long-term care purposes, that the Medicaid agency reviewing your application is going to ask for 5 years worth of financial records, so covering all of your accounts and assets over that time period, and review those records to see if you've made any transfers during that time period. And if you have, they may think that you've made the transfer for the purpose of qualifying for Medicaid and then can reject your application. So sometimes in Medicaid planning, we use what's called a Medicaid Asset Protection Trust. And when assets are in a Medicaid Asset Protection Trust for the entirety of the look-back period, they are not considered resources on a Medicaid application. So you can transfer assets to a Medicaid Asset Protection Trust, and then 5 years later, or whatever time period applies in your state for your particular type of Medicaid you're seeking, those assets after that time period has passed will not be considered your resources and will not be considered on the Medicaid application. So the trust, again, we're talking about some type of protection here. We're going to be talking about irrevocable trusts, and you can't be allowed to receive any principal distributions whatsoever from your Medicaid trust. If you're allowed to receive, if you do receive principal distributions or the trust allows you to receive them, then there's no protection that's afforded under that trust because the Medicaid agency is going to say, well, if you have access to this principal, take it out, or have the trustee give it to you, and you can pay for your long-term care yourself. You may, however, receive income generated by the trust assets, so interest and dividends, if the trust owns real property, maybe rent payments, but then again, your income is going to be subject to paying the cost of your long-term care as well. You cannot serve as trustee of a Medicaid trust, but you can retain certain rights, including the right to remove and replace your trustee. So that does allow you some indirect control, whereas if a trustee is not being friendly to you or not doing what you want them to do, then maybe you can remove them and appoint somebody who's more amenable to your wishes. If the trust owns your residence, you can retain the exclusive right to reside in your residence. In many cases, you can also retain the right to direct the trustee to sell your residence and purchase a replacement residence for you. But keep in mind that the trustee is not going to be able to make rent payments for you. So if you think there's a chance that you're going to sell your house and you'd like to rent, or you'd like to move into an assisted living, the trust is not going to be able to cover those costs. So sometimes it's a trade-off, and it's a balancing act to determine whether you think you might need home care or nursing home care in the future versus, do I want to keep all my assets and make sure I have enough so that I can pay for assisted living later on, which can maybe give you more options.
And Medicaid planning trusts are really designed for people of modest means. They are not for people who have significant assets. For example, if you have large retirement accounts, you cannot transfer those, and that's going to disqualify you based on the required minimum distributions that you have to start taking out when you retire. This is not for people who have millions of dollars. This is for people who have probably less than $1 million and want to take care of what they have so that their children inherit it. An alternative for people who have more money is that they either self-insure or they buy long-term care insurance. So long-term care insurance is very expensive. Many companies have gone out of business because of the number of claims that have been made. As a couple, you could probably spend easily $10,000 a year on the premiums for the policies. Generally, the policies pay a daily benefit for about 3 years. And if you can afford the policies, they are certainly something worth considering. And if it might be something you want to pay for your parents, for example, if you don't think that they want to engage in this kind of planning, or for yourself. But the more money you accumulate, the less you'll even need that, but it is nice when this happens to get a check every day. So it depends on how many years you paid the premium and whether you live long enough to see it collected or not. There are some long-term care plans that have essentially an insurance policy in them. And if it's not used on that there is a death benefit that is paid back. So that is another thing to consider. But generally, these types of trusts are designed for people of very modest means to protect what little they have. And, they want to remain at home and intend to remain at home.
And I think whether you would plan on doing Medicaid planning or purchasing long-term care insurance, it's probably, the sooner the better to start looking at the options and the planning that you want to do is a good idea. Okay, so we have some other considerations for trusts here. So when you're preparing your trust, you're going to consider how you're going to leave assets to your beneficiaries. And you may want to include continuing trusts. So that means that after you pass away, your beneficiary wouldn't receive assets outright in their own name, but there might be a further trust that's created for the benefit of that beneficiary. And planning this way can give your beneficiaries protections from creditors or divorce or estranged spouses, or even if they pass away before their spouse, that trust is going to pass down to the beneficiaries you've named in the documents, and not to their spouse, and who will then maybe share it with their in their next marriage and future children. So continuing trust can also be drafted to protect the assets for beneficiaries with different types of issues, where maybe you don't want the beneficiary to have full control over a large inheritance, and you want to have a trustee who's overseeing things and making sure the money's not being spent on a lot of different things. So beneficiaries with substance abuse issues, or beneficiaries in troubled marriages, or just spendthrift beneficiaries. So a trust can help protect those types of beneficiaries as well. And in addition, if you have a beneficiary with special needs, you can include supplemental needs trust provisions in your trust document, so that when that beneficiary inherits from you, those trust assets are going to be shielded, and that beneficiary can still continue to qualify for any government benefits that they're entitled to. So the thing about if you're looking to incorporate trust for your beneficiaries, you don't have to create all different trust agreements. You can include those provisions all within your revocable trust document, or if you also have an irrevocable trust, and in that trust as well. And so, so the last topic that we think it's important to talk about is that you can create a trust and sign a trust document, and you have a trust, and now you want to make sure that your trust is properly funded. So the assets that you've intended to place in the trust are actually transferred to the trust. So your life insurance policy, you want to make sure that the ownership and beneficiary designations are updated. If you're transferring your residence to your revocable trust, you want to make sure that that deed is completed and that property is transferred. And the same thing with your account titles. You want to update, your accounts, and your attorney will work with your financial advisor, or will help you to update the ownership of those different documents to make sure that you're achieving your objectives. And also, it's important to have a trustee who's going to try to understand the rules of the trust and what they are and are not allowed to do, because your trust terms have to be followed in order to be respected by the IRS, or maybe by the Medicaid agency, or by a court in some type of creditor action. So it's important that your trustee is up for the job, and that you and your trustee are communicating with your attorney if you have any questions about what you're doing with your trust, because you want to make sure that at the end of the day your trust is respected. And also, you'll have to make sure that you're following any tax reporting requirements. So if you've made a large gift to a trust, you will need to work with your accountant to make sure that the gift tax return is filed. And if the trust has to file income tax returns each year, or if you're reporting the trust income on your income tax return because it's a grantor trust, then you have to make sure that your accountant you're working with your accountant to report that income correctly. And then last, make sure that you have your beneficiary designations in place, as beneficiary designations can override the terms of your will or trust. So you just want to make sure that your beneficiary designations are working together with your trust and not against them.
So we have a couple of questions that have been submitted, and we have a few minutes left, so we'd like to touch on them, but we want to reiterate that these materials are going to be available to you online. This video of this conference is also going to be available online to you. And you're free to reach out if we did not get to the question that you posed to us, to either one of us directly. So someone asked, can your retirement plan have a trust as a beneficiary? So you can't put your retirement account in a trust for your own benefit. You cannot assign those types of assets. They have to remain in the plan or IRA name, but you can designate a trust for your beneficiary as the beneficiary of the plans if you don't want that beneficiary to receive the funds outright. For example, if they have special needs, if they would be disqualified from government assistance, or they need assistance, or you want to protect them and make sure assets continue on in your family line. So a special form has to be filled out and filed with the provider so that the benefits are paid out in the same manner they would be paid out to the individual, but to a trust. And the trust has to be structured a certain way. The rules are continually changing and getting more complicated about what the IRS requires. It used to be that a child could take out the distributions either in trust or outright based upon their own life expectancy, which allowed them, depending on how old they were, to keep the IRA going tax-free for quite a number of years. The IRS and Congress decided that that was too good to be true, and they are now requiring that a child or a trust for their benefit take out distributions not over their life expectancy, but over 10 years, which reduces the amount of time that money can continue to go tax-free and requires the income taxes to be paid in an accelerated manner. So that is something we continually come to have to confront, because quite a large number of our clients have a significant degree of wealth in their retirement plans. And that's a big part of making sure the exemptions are taken advantage of and that the terms of the trust for the beneficiaries are respected. Another question came up, can you have a special power of attorney for your trust and manage it yourself? So while you can have a say sometimes in the investments, and in other states they have bifurcated roles for trustees, and there can be an investment advisor, and you can, through either an LLC or directly, consider the investment advisor. But again, the more powers you have over the trust, the less bulletproof it is. But you can't have a power of attorney over the trustee. You have to pick somebody that you trust to take care of this. You can have a power to move and replace them, but you can't essentially direct how the trust is operated. Can the trust pay you a salary? Again, this is creating risks. While it is possible in certain circumstances to be compensated for actual work you're doing, this is again a red flag to the IRS. It involves getting comparable payment structures. It's something we would discourage you from doing. And if you think you need the money, you shouldn't be setting up this trust and trying to get something out of the backhand through a salary payment. Another question came up is, how do you terminate a trust that's uneconomical? Usually there's a provision in the trust agreement that says the trustee can distribute some or all of the assets, and that's the way to get rid of something. There is also typically in a well-drafted trust a provision that says if the trust is uneconomical because there's not enough in it to warrant the cost, or it just doesn't make sense anymore, to terminate it. And then there are also state law provisions that allow that, and then there are things that you would have to go to court for. So it depends on the agreement and what state it's in. Finally, the last question we'll be able to discuss in this is, if you are perhaps moving to another state, what happens with documents? So every state has their own laws that govern these things. Every state has their own forms of healthcare proxies and powers of attorney. And while they will remain valid if you move, we always encourage clients, if they move to another state, to have a lawyer who is licensed to practice in that state review it. We can prepare documents for you for other states, but we would have to bless that with people who are licensed to practice in that state. So we have attorneys we work with. We have an office in Florida. We have attorneys we work with in Florida. And that is the most common scenario, is that when someone moves somewhere else, they have to take what they've done here and have it reviewed and see if there's anything that needs to be changed. So this concludes our seminar. I hope that you found it worthwhile. We are both here to answer questions. If you want to reach out to us directly, we'd be happy to discuss your own situation with you in a private setting. So thank you for participating. We were glad to see so many of you out there, and we look forward to continuing this discussion with you if you wish.